General was rather against Isaac.
Yes, apologies to keeping you waiting, and good to see you both. All. Good to see you all.
Good morning. If it may please my Lord, David Dorset. I appear on behalf of the appellants in this matter.
Yes.
I apologize for the absence of my leader, Sir Gerald Watt, QC. We are instructed by Simon Moorhead.
Well, don't worry about the instructions, because we've got them on our papers. Just introduce counsel.
On behalf of the respondents, Mr. Justin Simon QC, Ms. Desiree Atesi, and Mr. Kwame Simon. My Lord, there is just one brief housekeeping matter on my part. In the record at page 45.
Yes.
In the record at page 45, paragraph 39.
Wait a minute, page 45. We've got two lots of numbering, or something's wrong. What is page 45?
45 is the appellant's written case.
Is this the electronic page? I think the pages are the same at this stage.
No, it's the other document. It's a document which in our case is called JCPC documents.
Yeah. Yes.
So page 45 and paragraph again?
Paragraph 39.
Yes, right. We have that.
On the third line,
yes,
the word give should be taken to read as given.
Oh, yes. Well, that's a given.
And likewise, at paragraph 40,
right.
The word resource should read recourse.
Oh, that's...
I believe my learned friend has also some brief housekeeping matters, so if I can defer to him.
Yes, Mr. Simon.
Thank you, Counsel. My lady and my lords, if we refer to page 52, which would part of the respondent submissions, at paragraph 8, and the last sentence, the issue of the suspension of the respondent is a matter of, it should be public law, not private law.
Oh.
And we continue.
I must admit, that did puzzle me. But there we are. Right, we got it straight now.
I was rather shocked when I saw it. I suspected it was a typographical error. So too is the publication of an adverse report, and I would add in here, by the appellants, following an investigation in which the respondent was never given an opportunity to be heard. And then at page 57,
the appellant in this context is the Ministry of Education, is he?
yes,
Yes.
please use. Well on. And then at page 57, at paragraph 25, the second sentence.
Right, yes.
The respondent respectfully submits that Cabinet, the word neither should be deleted.
Really?
So it should read, is a public authority,
Yes, I see.
but not a public sector employer. So we add in the words but, and rather than no, we say not.
I see. Right.
Now that is in respect of the submissions. I have also two other matters.
So what is your... I'm jumping slightly ahead, but one of the points which you make, I think, is that... well, no, we'll come to it in due course. We'll come to it. I was going to ask you about the status of a public sector employee in relation to the industrial courts.
Yes.
That
certainly will be coming into the arguments.
Yes, thank you.
Okay, now there are two documents which I have handed over. One is a chronology. I call it the full chronology of events prior to the legal action.
Where do we find that?
The Lordship should have a copy.
Yes.
It's passed on to the clerk. 1 second, sir. That would assist in respect.
We have got a chronology somewhere. haven't
Yes, there is a chronology by the appellants,
Yes.
but mine is a little bit more detailed.
Right.
Deals with matters prior to the legal actions.
Yes. Fine.
And then the second document is the official version of the case of Regina Shoesmith versus Ofsted.
Right.
I think the version which is before the court comes from, what's it? Email, electronic copy,
Yes.
but we have actually provided with the ICR copy, Industrial Court Reports copy.
Thank you. All right.
It is my understanding that this is the preferable,
Well, it is, yes.
preferred document which should be submitted.
So that's the housekeeping. isn't
That's
it?
the housekeeping.
Thank you very much. Right. I will return to Sir Gerald.
My Lord,
Sorry, Mr. Dorset, I'm quite right. Yes, I apologise. Yes.
my Lord, as you would see from the statement of facts and issues, that there are really two issues that fall for consideration in this appeal. We are looking at page 31 of the record. The two issues being the fixed date claim form filed by the respondent constitute an application for judicial review,
Right.
for which leave is granted, and secondly, is the nature of the controversy disclosed in the fixed date claim form a private law claim involving an employment dispute for which the appropriate disposal is the industrial court. My Lord, as you would look at our written case, when you get past the introduction, we build our case on three heads.
Can I just ask, was the second point one which you argued in the Court of Appeal?
Second point.
The second issue, was that argued in the Court of Appeal?
Oh, yes, it constituted 42% of our written case.
Right, right.
And in fact, even though it is referenced, I believe at paragraph 18 of the Court of Appeal judgment in terms of what the submissions of counsel were, it was not discussed or dealt with by the Court of Appeal itself. But it certainly, it was part of the written case.
Mr. Dorset, the proceedings that are before us are the proceedings in which a declaration is sought.
Yes, madam.
And the question is whether those proceedings should be struck out. There are separate proceedings in the industrial court.
That is correct.
And an order has been sought in those proceedings that they should be struck out for want of jurisdiction.
Yes.
Now, that's not an issue which this court can determine.
No. We're not asking this court to determine what is happening in the industrial court. This is an appeal from the High Court.
Yes.
Yes.
And so how does the second issue, the second issue rather looks like the issue that the industrial court will have to determine whether the claim before it is one for which the appropriate forum is the industrial court. That's the issue of jurisdiction that it has to decide.
Yes, well, the reason why we raise the jurisdiction question is because the industrial court deals with matters between employer and employee, and we say that the Board of Education is not the employer.
Yes.
No, you say the Cabinet is.
What's that?
You say the Cabinet is.
Yes, that's correct.
Yes, so that's why you say
Yes.
that any claim against the Cabinet
Yes.
should be really an employment claim and should be pursued somewhere else,
Yes.
although we have to deal with the words notwithstanding the respondent was employed by a public authority.
Yes, my lord, yes. Also, the reason why that second issue is there is because of the letter displayed at page 21 of the record.
Yes, but you tell us on page 30, at paragraph 17, that you're still awaiting a decision
Yes.
as to whether the industrial court has jurisdiction, the contention being that it has no jurisdiction because the employer is the cabinet and not the board.
Yes. We're still awaiting that decision.
Yes. Well, how can this board determine an issue on which a decision is currently pending in other proceedings before a different body?
No, we are not asking this court to make any determination of the proceedings before the industrial court. All we are simply seeking to do is per the direction of the board at page 21 of the record. If you see the letter from the registrar.
Yes, this was the board's.
Yes, the board would also wish to be addressed on the nature of the respondent's employment, including the basis, and whether her claim should not be regarded as a private law claim effectively for wrongful or unfair dismissal.
Well, maybe the board was at that stage raising a point which looks differently now, but we certainly want to consider what the nature of these claims is, and I think we better get back to the basic point, and I suspect it will emerge insofar as it's relevant what role the status of our employment has and what role the industrial court might have. But I think if we focus on the first point for the moment, that will require us to identify the nature of the claims which are currently being made. The one thing that seems to me clear is that she is not presenting claims as an employee against her employer. She is putting them on a different basis. You may say that she is claiming against someone who is in law the employer, but that's not how she sees the claim. She sees the cabinet as not her employer, and she sees the Ministry of Education as someone who effectively interfered in her relationship. And what we're concerned with primarily is what is the nature of that claim in terms of the administrative law rules which apply, which seem to distinguish between judicial review and some other claims, public claims, some other administrative claims, such as declarations.
Yes, my lord, I understand. Getting to my first point, which is the nature of the claim. Yeah. We are of the view, our submission is that the nature of the claim prosecuted in the High Court is a judicial review claim. And I would draw the court's attention to the claim as filed in the High Court at page 72 of the record. And you will notice, my lord, that the claim, the fixed date claim, which begins at page 72 and continues at page 73, is for 6 declarations. Mm-hmm. The first 3 declarations we respectfully submit is declarations that seek to challenge the legality of the actions by the executive. The second 3 are declarations 4, 5, and 6 are declarations that deal with procedural impropriety. So in this claim are 2 of the 3 heads of judicial review. Judicial review, to use the language of Baroness Hale in the Card case, is an artifact of the common law. And what it is basically a proceeding in which the legality of a decision or the procedure by which a decision has been reached is challenged. And that is exactly what is being done here. And as the more recent case, I would call it the Macalac case, makes clear.
Michalak, I think we called it when we were in it, but it probably...
Michalak. The ordinary outcome of such a proceeding, a judicial review proceeding, is that there is a declaration and a quashing of the actions or decisions that were deemed unlawful. And so what we respectfully say, this is precisely...
Well, supposing she's not interested in that, and supposing that at the time when she issued this, she was claiming to continue as Executive Secretary to the Board of Education, wasn't she? She was hoping to go on.
Well, even at this time,
Supposing she was claiming these declarations because, as Executive Secretary, she felt that outsiders, even if they were public officials, the Cabinet and or the Minister, were purporting to have authority in respect of her, which constitutionally they didn't have. She wouldn't be interested in setting aside the decisions. She'd just be interested in a declaration that they weren't entitled to, so to speak, interfere. And she might, I suppose, now that her employment has ceased, she might actually use that sort of declaration for a different reason, not as a guide to future conduct, but as a basis for claiming damages on the basis that they actually caused other people to terminate her employment. So is it necessarily the case she's seeking to challenge any past decision?
well, I mean, she is by seeking the declarations, we're supposed to say, she's challenging the decisions. And what we say, when one looks at the substance of the claim, if you look, for example, at page 74, the affidavit, and this would be the evidence in support of her claim.
If I'm a public employee, and I'm taking an example, I'm the rail regulator. I regulate the rail companies, right? And the Ministry of Transport comes along to me and says, I direct you to do X, Y, Z. Now, and you as the rail regulator say, sorry, I'm independent, I've got statutory functions, your functions as minister don't include giving me directions. That's an issue. Now, he's not actually, he's not challenging a substantive decision, he's not challenging the substance of the direction which the minister proposes to give. What he's doing is challenging the proposition that she has legal authority to give him directions. And that proposition isn't really a decision in judicial review terms, is it? It's just he wants to establish, the rail regulator, what the position is, what somebody's authority is. Is that judicial review in your terms?
Yes, my lord. I would accept that those kind of decisions are amenable to judicial review. But the question...
You say they are?
Well, yes. I mean, and any challenge...
Any challenge?
Just about any challenge to a decision made by a public authority would be amenable to judicial review. But we have to look not just at what I call the surface issues, but the substance of the matter. And if I may direct your attention, my lord, to page 74, which is the evidence in support of what we say really is a judicial review claim. The affidavit in support of again, we call it a judicial review claim. She says, the respondent says it's really just a case for declarations. But if you look at this affidavit, the evidence in support of the claim, the affidavit begins at page 74 and continues to page 78. My lord, you will see that the evidence, the claim, the statement is exactly the same as the witness statement in the industrial court, which can be found beginning at page 166. It is exactly the same evidence, the same issues that are being ventilated in the affidavit in support of what we say really is a judicial review claim are the same issues that are being evidential issues and otherwise that are being, word for word, line by line, is in the industrial court. No matter how you dice it or how you switch it.
Could you give me that page number of the statement in the industrial court again?
Yes, page 166. 166. It begins at page 166 and continues to page 171. And what we say is that when one looks at what is happening here, we respectfully submit it is not any different from what happened in the Swan case. The Swan case was a Privy Council case from the Turks and Caicos Islands, and it is at page 411 of the record, and beginning there at page, at paragraph, the Swan case begins at page 411 of the record.
Right.
And in particular, I want to draw the court's attention to paragraphs, begin at paragraph 13 to 16 of the Swan case, and the points that was being made by Lord Neuenberger, and which is the point that we would want to emphasize in this case, is that private law claims involving employment disputes should not be brought by way of judicial review, and that the public law arguments that the respondent...
Sorry, it should not be. I mean, I'm getting a little muddled at this point. I mean, I thought your first assertion was that this was a judicial review claim.
Yeah, yes.
You're now saying it is in fact a private law claim.
She has brought it as a judicial review claim.
I see.
Yes.
Right.
But when one looks at the substance of it, and that is why I direct the court's attention to the witness statements and the affidavit, it's exactly the same.
Your argument at the moment seems to be assuming that if the legal substance of a claim falls within the area of public law, then the appropriate procedure is judicial review.
Yes.
And you cited cases like O'Reilly and Macman, which show that that's, broadly speaking, the approach adopted in the English system. But we're concerned with the interpretation of the expression as it's used in the CPR in Antigua. And in that context, the distinction that seems to be drawn is between remedies which are specific to public law, the ones that are mentioned specifically are certiorari, mandamus, and prohibition. But no doubt there may be, if one puts one's mind to it, I dare say there are other, specifically public law remedies. They are categorized as judicial review in the CPR.
Yes, ma'am.
But remedies which are available more widely, declarations, damages, injunctions, orders for restitution, are dealt with as other forms of remedy, which some of them are categorized as administrative orders, others are not. I'm looking at this, we have it on page 479 in the authorities. And the reason I'm raising it with you is that it may not be appropriate simply to assume that effectively O'Reilly and Macman is a law of Antigua if the CPR suggests that the term judicial review is being used with a narrower and more specific meaning.
Yes, my Lord. If I may, in my argument, I am not relying on O'Reilly and Macman. I've left that both.
You accept that, right?
But I am going at what substantively is judicial review. Judicial review is, our case is not a creature of the CPR, it's a creature or an artifact of the common law. And so, as a matter of substantive law, it is a review of the decisions of public bodies, and in determining whether or not one should be granted leave to pursue a judicial review claim, one must consider, one, the substance of the matter, and to see if there are, in fact, alternative remedies.
The difficulty I had a moment ago was that I thought you were saying that substantively this is a private law claim.
Yes, yes.
You say then brought as a judicial review claim, but if we're looking at the substance as you invite, and if it really were a private law claim, why should it be treated as a judicial review one?
No, what I'm saying is that it is brought under CPR 56.
Yes.
And under CPR 56, my lord, as you can see, there are a number of
Yes, heads.
heads, yes. The heads...
Why does it fall within JR as opposed to, for example, an application for a declaration in which a party is a court or public body?
The reason why we say so, my lord, is because when one looks substantively at the matter, and I, if I may rely on what was stated by my learned friend in his written case, which begins just after our written case, and I believe it is at paragraph 7 of his written case. Page 51 of the record, page 51.
Right.
And this is a point that we accept.
Right.
To the extent that an application is made for a declaration. But in reality, is an application for certiorari. Well, let me begin so that we can be in context. Paragraph 6, if I may.
Well, I think we've got paragraph 6 because...
Yes, but in particular, the last point,
yes,
where the respondent respectfully submits
yes,
that one of these coercive remedies must be sought whether directly or indirectly.
right.
In the application, it is to be considered as one for judicial review. And what we respectfully submit, this is a case where they were not seeking the coercive remedies directly, but they were seeking it indirectly, because the natural consequence of a declaration that the decision of the public body was wrong, we say in light of Section 20 of the Eastern Caribbean Supreme Court Act.
Shows that?
Yes, inevitably, the court would be under a positive duty to quash the decision.
But the critical element can't be that the remedy is coercive, because it's apparent that an injunction or an order for return of property is not judicial review. In fact, it's not an administrative order at all. That appears from Rule 56(4). What the three listed remedies under judicial review have in common is that they are all specific remedies confined to public law, and they're all historically remedies which required the obtaining of leave before the appropriate writ could be obtained.
Yes.
And in both those respects, they differ from declarations, injunctions, and other remedies which are more generally available in the law.
Yes, I understand it. Well, what we say, my lord, is that and I hope I'm not being unfair to my learned friend. These three remedies here, I believe he's referring to these as coercive remedies.
Yes, I know that's what he said, but I'm just questioning whether that is actually what is the relevant aspect of them, given that other coercive remedies are clearly not judicial review within the meaning of Rule 56.
Yes, I understand that, my lord. And what I would say, my lord, is that the manner in which the Part 56 claim has been brought, where ostensibly the respondent says, I just want a declaration, that is a convenient way of trying to avoid getting leave or having to apply for leave before pursuing what would otherwise be a judicial review claim.
Supposing she had sought an injunction against the Cabinet and against the Minister of Education from further interfering with her employment, would that be a judicial review claim?
Standing on my feet, I could not say exactly. I'll be honest with you.
I think it may be an important point because we're considering how far every claim against a public body, who she says is not her employer and doesn't have authority to act on behalf of her employer, is necessarily a judicial review claim. And if there are some which are not, we then fall back to the critical question whether a declaration, which side of the line it falls.
Well, this is what I would say in response to that question. If one would bring a claim for an injunction, invariably the injunction being kind of an ancillary remedy, there must be a substantive.
No, why should there be? You can, if you as an public official say, I mean, go back to my example of the rail regulator. If he says my job is being made difficult or impossible because the minister claims to be able to instruct me to do X, Y, Z, and I believe this is not her entitlement, I want an injunction. I mean, this was a pretty radical remedy, but I want an injunction to stop her doing this. He doesn't need anything more. That's what he's interested in.
Yeah, well, with respect, that type of remedy being sought, in my respectful view, seems to be in the nature of a prohibition for prohibiting the unlawful act. The unlawful act being interference with the performance of one's duties. And so what has been called an injunction, and I mean no disrespect at all, I would respectfully submit that in substance, it is really a prohibition. And if a prohibition, then clearly it would fall under the realm of judicial review. That is how I would answer that particular question, and I hope I have satisfied you on that.
But what scope does this leave for the separate heads of injunction, which can be sought instead of an administrative court order or in addition to under CPR 56 paragraph 4, or for the separate head of declaration, which can be sought under 56.1 little 1b. I mean, do you say that?
My Lord,
when do they arise? When? Give us some examples.
Effectively, I do recall you making reference to 56.11b.
Yes.
And I believe you referenced something else.
I referred to 56.1.4 at the bottom, where it says, in addition to or instead of an administrative order, the court may, without requiring the issue of any further proceedings, grant an injunction.
Yes. Okay.
I suppose you say that's an alternative to one of the others.
Yes. Yeah. What I would respect.
But anyway, what scope is there for declaration?
Yes. One example that I would perhaps offer is that a particular person, it might be a public official, it might be a private body, there might be an important issue of public law for which there needs to be some clarification by the court. And in order to obtain that clarification, they come by means for a declaration so the court can state precisely what the law is so other persons can be guided. So I think that would be an appropriate case.
Why wasn't that what she was doing here? She was saying, at the time when she was still hoping to be an employee, perhaps, she was saying, I want to be guided, or I want the court to give guidance as to what the authority of the Cabinet and the Ministry of Education is. And now that she ceased to be an employee, we may ask Mr. Simon what the purpose of these proceedings is, but one possible purpose, which I suppose might be suggested, is that a declaration establishing that these things were, that the Cabinet and Ministry of Education were not entitled to act as they were might be relevant to a damages claim if their acts led to her losing her employment.
All right, my lord, if I may say, when one looks at the claim where she seeks these various damages,
Right.
at the crux of her complaint is a suspension letter dated the 18th of July, 2014. So these various declarations spring from the action of the public body in issuing the suspension letter. A suspension letter where you are directing a person for X period of time, you're no longer to function in a particular job or employment, raises in classic terms a employment dispute or issue, which is, we respectfully submit, is best dealt with in the industrial code, because if you look at the...
It would be if you were suing the employer, perhaps. But she says she's not suing the employer. She's interested in suing other people who intermeddled and brought about her suspension, namely the Cabinet and the Ministry of Education. So, I mean, she's... that's what the difficulty I have.
I know, well, my lord, she may say that the Cabinet is not her employer, but we respectfully submit that she errs in that, and I want to put...
No, but we can't decide that issue. That's going to be decided in the, probably in the industrial court. We have to take her claim for what it is. Maybe you can...
Well,
maybe you can say that it's misconceived because she's suing someone who is in fact her employer, and therefore she's started on a false premise. Well, that's a different point from any we've got before. We must take it for what it's worth.
Yeah, but my lord, if I may respectfully direct the court to the Interpretation Act, page 210. Page 210 of the record.
Yeah.
And section 18 of the Interpretation Act, where, and this, my lord, must be seen in the context of the Board of Education Act, which is at page 192, where section 11 of the Board of Education Acts...
Sorry, where are you now referring to? In the context of what? Give us a page reference.
192.
Page...
Sorry.
The Board of Education Act begins at page 192.
Right, yes. So
And
section
in
10.
particular, section 11,
I have it, yes.
which may be found at page 195. The reason why I say that is because when one reads the Interpretation Act, section 18, it says, subject to the Constitution, words in an enactment, the relevant enactment, in this case is the Board of Education Act.
Yeah.
All right? So, subject to the Constitution, words in an enactment authorizing the appointment of a person to any office shall be deemed to also confer on the authority in whom the power of appointment is vested. A, power at the discretion of the authority to remove or suspend him, and for relevant purposes, B, subsection 3,
Yes.
the power to fix or vary his remuneration.
Yeah.
So what we respectfully submit in that when one looks at the letter of suspension, which she claims, the declaration that's specifically been sought, is that a declaration 3, a declaration that the second defendant's action in instituting an investigation against the claimant in respect of her duties as executive secretary of the Board of Education and for the purposes contained in a letter of suspension dated 18th July was without legal basis. The reasons why the executive was acting as it was, is stated in the suspension letter.
Well, the provisions you've just taken us to would appear to imply that the appellant was the holder of a statutory office.
I really mean the respondent.
I beg your pardon, the respondent was the holder of a statutory office, and the appellants were exercising a statutory power or statutory discretion in respect of her tenure of the office.
Yes.
And if that's so, then it's not an employer-employee relationship at all.
Well, I would.
It's like Ridge and Baldwin.
Here is what I would say. And my learned friend refers to the ready mix case.
Oh, well, yes, I see. There are different ways of looking at who's an employee for different purposes in the law. I suppose the point I was making, or suggesting to you, is that if the person is a statutory office holder and the power being exercised is a statutory power, and the allegation is it's not being exercised in accordance with the law because, for example, there hasn't been a fair process carried out, then the implication would be that you're in the territory of public law, but for the reasons we looked at earlier, it doesn't necessarily follow under the CPR that the declaratory relief sought is classified as judicial review within the meaning of 56.1, paragraph 3.
Yes, my lord, but what I respect, when one looks at 51.13, judicial review includes these remedies. We respectfully submit includes, is suggestive. It is not limited to these.
No, I mean habeas corpus, for example, might be
yes.
A form of judicial review remedy.
Yes, and we would respectfully submit. It would also include an appropriate declaration as to the legality or otherwise of the decision of a public authority. That is why it is stated in those terms, includes. Includes. And as I gave an example about where one can rightfully ask for a declaration where there is no executive decision that has been challenged, where one is just seeking clarity on the law. Well, that is not judicial review. But on the judicial review, one can get a remedy to include a declaration where it's not so much clarity of the law, it's a declaration to say that the action taken was wrong.
Is it relevant to your submission that the first three declarations sought are not prospective in effect, but look back to specific matters?
The first three declarations, yes, they look at prior action. Yes, prior. They look back at prior action done by the executive prior to the initiation of the claim. My Lord, we readily accept that.
Supposing you're claiming a declaration against a public authority, the invasion of my premises was unlawful and I claim large damages. Is that due to JR?
It would perhaps fall under constitutional motion, A. All
right.
Yeah.
That's sidestepping the point.
Yes. Yes. A. Under, by way of originating motion or otherwise for relief under the Constitution of any member state or territory. And in fact, we make the point in our written case. And my Lord, if you look at the Constitution, and we have it, it's the first authority, page 177. Page 177. if you look at section, the Constitution extract that we have provided begins at page 177.
Right.
It continues to page 182. Section 18 of the Constitution, where it says, if a person, 18.1, if any person alleges that any of the provisions of section 3 to 17 inclusive has been or is likely to be contravened in relation to him, then without prejudice to any other action, that person may apply to the High Court for redress. 2, subsection 2.
But, I mean,
my Lord,
are you seeking to suggest, this is an answer to my question, is it, just to show it's a constitutional relief?
but more than that,
Yes.
subsection 2. The High Court shall have original jurisdiction to A, hear and determine the application, B, determine any question arising, and you see, and may make such declarations and orders. So even in the context of an originating motion seeking relief under the Constitution, the Constitution itself provides that the court, in dealing with such an action, may make such declarations and orders and issue such writs and gives such directions as may be appropriate. And so even under 56.1a, declarations will still be appropriate or may be appropriate. And likewise, we respectfully submit in 56.11c, judicial review, declarations may also be appropriate.
Can I just go back to my example? It is well established in this board that constitutional relief is not appropriate if there is an ordinary civil claim which you can pursue. In my example, it's perfectly possible, is it not, to conceive of a minister committing a trespass due to misinterpretation of his or her powers. A claim against them for that trespass would not require a constitutional motion.
No.
No. So you start a claim for a declaration and you tack onto that a claim for damages. Is that judicial review?
Well, you may call it judicial, but it ought not to proceed as judicial review.
No, so it's what's perfectly ordinary public law claim for a declaration with an associated claim for damages, is it?
No, my Lord, if
What is it?
If it's trespass.
As you say, it's a civil claim, do you, or what?
Yes, a private law claim.
You say it's a private law claim.
A claim for trespass, whether it's done by a minister or an ordinary citizen, trespass is trespass is trespass.
I see. So we have to read 56.11b as what? As relating to
Public law matters.
public law matters, I see.
Yes. Not just any action by a state, a court, or tribunal of a public body. It's action in the realm of public law.
Well, is there any authority for that? Because it doesn't say that, does it? It says that this part deals with applications for a declaration in which a party is the state, a court, a tribunal, or any other public body.
Well, I mean, it doesn't say it expressly, but I would respectfully submit that when one reads the entirety of Part 56, it is clear that we're dealing with.
I mean, they would have been acting. Supposing a court failed to follow the proper process for ordering execution, and you wanted to, I don't know whether you can claim against a court for declaration and damages, but it wouldn't be an answer. That's a private law claim because it's just a trespass. Why should it be an answer if it's the case of a minister? Surely the fact is he's purporting to act as a public body, but you are saying your authority doesn't extend that far, and this rule seems to say that that is an administrative action.
Yeah, well, what we say is that if a minister acting as a public body commits a violation of some breach of a private law,
Yes.
that really substantively is a private law action that ought to be pursued.
Well, he's not. He's trying to. He does it pursuant to his ministerial functions. I mean, take the case where the customs authority refuses to return due goods which it has seized.
Yes.
And you say, I'm entitled to those back. Well, in one sense, it's if it's not entitled to do it, it's committing a private wrong, but it's a public body, and surely that's a situation which would fall within this sub-rule.
Yes, well...
You claim a declaration that the customs doesn't have any authority to do this, and I want my goods back.
Yes, well, what I say, in any of those instances or examples that you give, the court has a discretion as to how it's going to proceed. The issue is the discretion, whether it's going to allow the claim to proceed by means of a public law action or direct that the matter proceed by private law is a matter for discretion of the court, but the discretion must be exercised on a principled basis. And what we say in this particular case, when one sees the substance of the matter, and again, I invite you to look again at the affidavit evidence in the witness statement, that really, when one gets to the core of the matter, it is a private law action complaining about her employment, her constructive dismissal.
Can I just get behind the legal argument for a moment and look at the practicality? You say it's judicial review because it's against her, against a public authority, the Cabinet, who you say is her employer. That's your position. Therefore, you say you need leave. So let's move to the leave question. And your answer is you should go to the industrial court because this is a claim against the employer. Right so far?
Well,
you've got an alternative remedy.
That's right.
Yeah.
That's right.
Or if it's not judicial review, if you're wrong about that, then it should be struck out because it's a private claim and it also should be in the industrial court. You never got onto that really in the lower courts.
If it is not judicial review, it cannot proceed by Part 56.
Okay, so therefore strike it out.
Yes.
But that I don't think was really argued, was it? But that all proceeds upon the basis that the Cabinet is the employer. If the Cabinet is not the employer, and as I've understood the respondent's case, she says it isn't, she says it's the Board of Education, then she hasn't got an alternative remedy in the industrial court. Why shouldn't she be given leave on the JR?
Well, we say that the court, in looking at a matter such as this, is under a duty to get to the substance of the matter. And if I can draw the court...
Yes, but I'm working now on the basis that it is JR. Her case is, it is against somebody who is not her employer. Well, your answer to the JR would be alternative remedy, but there isn't one in those circumstances.
Well, I'm not quite certain that she, and I hope I'm not misleading myself, in the claim in the High Court, the issue of her employment was not raised by the respondent, but rather by the appellants. And what we say, if I can direct the court to the judgment of Justice Henry. The judgment of Justice Henry, it begins at page 118. 118. And I draw the court's attention to paragraph 7. Paragraph 7, page 120. The last, well, it's the second sentence.
Sorry, you're going to have to help there, right?
Page 120.
Yes.
Page 120.
Paragraph?
paragraph 7.
Thank you.
And where Justice Henry says the issue in this matter is whether the claim herein is, in fact, a claim for judicial review. We have to refer that. But then she goes on, and at paragraph 12, she says there, the third line, it is also clear that applications for judicial review are identified by the type of remedy sought. They are claims for the prerogative orders of certiorari, mandamus, or prohibition. Of course, a claim for judicial review may also include a prayer for the clarity and other relief, so that an in-depth analysis of the nature of the claim is not necessary. An examination of the remedies sought
Well, you say it's wrong.
will identify whether the claim is one for judicial review. And we take issue with the statement that there is no need for an in-depth analysis.
Yes, I think we understand that. You say
Yes.
it's a matter of substance, and we've got to look at the
Yes,
substance.
and what we say, when one looks at the substance of the matter, we would say that Cabinet is in fact the employer, and this is an employment dispute. Yes, she may say otherwise, but that is not the end of the story. The court is required, we respectfully submit, in this case the High Court is required to do more than just look at the remedies and say, oh, you just asked for a declaration, so we just, there's nothing.
I don't think you can challenge the way in which she puts it. I mean, the substance which we're interested in is the substance of what she is asserting. And if you are entitled to challenge that at all, it must be on a different basis, namely that her submission that the Cabinet is not her employer is hopeless and should be struck out as abusive. We can't decide that. We can't proceed on that basis because that's a live issue in another area. So, I mean, we must proceed on, surely the substance must be what she is in substance alleging, and in substance what she's alleging, which we have to evaluate in terms of the rules, is that she is suing people who are not her employers.
Well, my Lord, I hear what you say on that point.
I'm glad.
Can I ask you what you have to say about another point? You've only taken us to Rule 56.1.
Yes, ma'am.
If you go on a few pages to Rule 56.7,
Yes.
which is on page 483,
Yes, ma'am.
an application for an administrative order must be made in Form 2, identifying whether the application is for A, a declaration, B, judicial review. Now, that appears to treat a declaration as being something which is different from judicial review.
Yes. Yes, and I accept that. And I gave an example where the issue is not seeking a declaration on an action, but seeking a declaration on the law.
Yeah, well, not different in the sense that they are mutually exclusive. I mean, the 56.71 appears to assume that something is possible to identify whether an application is, on the one hand, for a declaration, or on the other hand, for judicial review. I mean, on your approach, I'm not quite sure what you do if it's a declaration sort of an issue arising in public law. You wouldn't be able to say, well, it's A, because you'd say, well, it's also B. And you couldn't just say it's B because it's also A.
Well, my Lord, I think we have addressed that issue in our written case, my Lord. at paragraph 12 of a written case, page 38, page 38. And as you can see there, my lord, the appellants accept that in administrative law proceedings brought under CPR 56, that a litigant is permitted to apply for declarations in matters for which a public body is a party under the narrow confines of 56.11B without the need for obtaining leave. It is axiomatic that in law, context is everything. And we cite the case of David.
Right, yes.
Therefore, a CPR 56.11B application for a declaration must be seen in the context of 56.1. And what we say, my lord, is that in the context of CPR 56.1, an application for an administrative order on the 56.11B must in substance be a different type of application from that brought under CPR 51.1A, an application by way of originating motion for constitutional relief, for which declarations are also available.
I see. So under 56.7 is the puzzle to be resolved by saying that A is only concerned with with declarations which are not judicial review declarations,
Or
whereas B includes declarations which fall within the scope of judicial review.
Yes, madam.
I see.
I think that is a way I would need to put it.
Right, I see. Yes.
So how do we draw the line in the present case?
We draw the line, my lord, by doing what I says ought to be done. Look at the substance of the matter.
Yes, but if the substance of the matter is you're seeking clarity for the future, that's not JR. If the substance of the matter is that you're seeking to set aside a past decision, it is JR. What if the substance of the matter is that you're seeking to establish a right to damages?
Well, with respect,
In respect
if one is seeking clarity and it's an appropriate case for declaration, the clarity has to be on a matter of public law, not a challenge to a decision or action. If you are challenging an action or seeking clarity on an action, the clarity being, I want to know if this action was right or wrong. That is judicial review. If you want that kind of clarity. And that is what we say. I mean, she may say, yes, I want clarity to know if the minister was wrong. Well,
So if the minister says, I'm entitled to give you directions, and you seek a declaration that she's not, are you seeking in your terms a declaration as to a matter of public law, or are you seeking a declaration as to an action or a decision?
well, in this case, the minister did in fact give direction, but if it was more or less like a hypothetical question,
Yeah.
all right?
Well, she says, I'm going to give you directions. Is that an action or a decision? Or is it a challenge on a matter of public law? Supposing she said, I may give you directions, and you then claim a declaration she's not entitled to. You're not challenging a decision or an action because she hasn't taken it. But
Very good. Well,
so you say it's all right. I mean, it seems a very curious distinction to me. It's a very narrow line.
well,
Some declarations are all right.
well, I mean, in law, sometimes you do have to draw a narrow line.
There isn't much trace of it in the rules.
What's that?
There isn't much trace of this narrow line in the rules. Why should we squeeze the concept of declaration to the extent you're suggesting?
Well, my lord, I have drawn your attention to what the Constitution says about declarations, and I hope I'm not speaking out of turn, but I think we can accept that certainly in judicial review, declarations are a common feature.
No.
So the narrow line that I am seeking to advance is not totally out of the field. I mean, declarations are a common part of public law or administrative law. The question is that, given it being a feature of public law, exactly where do we fit it in this architecture? That really is the issue. Because if we don't, my lord, the appellants are fearful that every person who has a grievance with a public authority and what a public authority has done or is doing would simply come to the court saying, I don't need leave, I just want a declaration.
Well, maybe,
and the protection.
maybe the solution to that, the simpler solution, might be to amend the civil procedure rules. Because the whole problem arises because your rules are different. They have a narrower, apparently narrower concept of judicial review, or at least one which must be distinguished from claims for declaration, which isn't applicable in this jurisdiction in the United Kingdom. It's applicable in the jurisdiction we're sitting in, but not in the country we're sitting in.
Yes.
With respect, this is what I would say. Given that judicial review is an artifact of the common law, it is a matter of substantive law.
What judicial review is? That's a very curious proposition.
Well, my
judicial
lord,
review are just words to describe.
My lord,
I mean, it's a form of, nowadays in England, it's a form of procedure that was introduced in 1977 by Order 53, which introduced a requirement for leave for all relief, forms of relief, which could be granted under that procedure. Now, until then, you didn't require leave in England to seek a declaration in a public law matter. And, we can't just take it for granted that the law of Antigua has followed the same path. In fact, it's apparent that it hasn't, because if you look, for example, at 56.2, this deals with standing, and it adopts the sufficient interest test for standing, but not generally in respect of administrative orders, but specifically in respect of applications for judicial review. So and historically, the generous standing rules for the prerogative writs are linked to the requirement for leave in order to be able to obtain the writ. Now, if you're seeking a declaration or an injunction or damages, then or restitution, then you don't fall within 56.2. You don't qualify simply by virtue of a test of sufficient interest. Presumably, you have to show that you have standing as an individual to obtain the particular form of order that you're seeking. So if it's a declaration that your rights are X, or that somebody else has no right to do X to you, then you're bringing that by virtue of your own legal interest in obtaining that declaration. It's a different approach from the approach set out in 56.2 for judicial review.
yes, my lord, I accept that. But if I recognize the particular relevance and restriction of that part 56.2 is for judicial review only. But my lord, if I can, to the question about, maybe the CPR needs to be amended, if I can draw the court's attention to, again, I hope I'm pronouncing this word correctly, Michalak.
Michalak, yes.
Michalak.
Yes. Which we had not long ago. So
That's right.
Where is it in the bundle?
It begins at page 225.
Thank you.
and what was held, point 2. That judicial review originated as a common law procedure and not by virtue of any statutory enactment. I would also say, my Lord, judicial review is not something that originates by means of rules of court. And as a matter of the common law, it has always been the case, even before CPR, that in order to proceed with an application for judicial review, leave must be obtained, because that is the way of the court having a built-in protection, if I may say, so that vexatious claims do not trouble the court. And we make reference to that, my Lord, at paragraph 7 of our case.
If you read what's said in the dicta that is cited in Michalak, I'm looking at paragraph 30.
30.
Well, I'm looking at 32 and 33, and I'm wondering if I agree with them. It's certainly true that 33 is correct in saying remedies remain the same as those under the prerogative writs, so far as you confine yourself to certiorari, mandamus, and prohibition. But one of the points of Section 31 of the 1981 Act was to unify, have a single procedure which would encompass both what used to be the prerogative writs and also what had been private law remedies.
Right.
My Lord, my reference to Michalak is simply to highlight the point that judicial review is a matter of substantive law, the common law. And in the Michalak case, again, I've made repeated reference to the Cart case. The scope of judicial review is an artifact of the common law. What judicial review is not a matter of rules of court. It's a matter of substantive law. And substantive law cannot be altered by subsidiary legislation such as rules of court. I mean, I hope I'm correct on that point. We're dealing with substantive law. Judicial review. And so that is what I would want to see with respect to the Michalak case, my Lord.
What is your definition of the substantive scope of judicial review which can't be altered by procedural rules?
One looks simply at the remedies sought without regard for the substance. And what
you look simply at the remedies sought without regard for the substance?
Well, that is what, as we read the judgment, paragraph 12. Paragraph 12, my Lord.
Page?
The judgment begins at page 118. Yes. Paragraph 12. Third line. Paragraph 12, third line.
Yeah. Yes, well, we appreciate you criticize this, yes.
Yeah, well, what I'm saying, if one looks also at the Court of Appeal judgment, paragraph 74.
Page 74, paragraph?
Paragraph 74, the court of Appeal judgment beginning at page 128,
Right.
paragraph 74, page 155.
Yes, I've got it. Yes.
The Court of Appeal says there, in the case at bar, the learned trial judge was quite correct in concluding that an in-depth analysis of the nature of the claim is usually not necessary, and an examination of the remedies will normally identify whether the claim is one for judicial review or not. And we say that is where the danger lies, because what one would simply do is simply claim non-judicial review remedies, when really you have a judicial review claim.
Well, you haven't answered my question. My question was, what is your definition of the unalterable substance of judicial review?
The scope does not include private law or employment matters, and I make reference to as found in the book Judicial Remedies in Public Law. We have quoted an extract from Sir Clive Lewis's text, Judicial Reviews.
Well, I think we know, I mean, we got that point.
What he says there is that disputes arising out of employment relationships.
Well, let's not go around in circles. I mean, this lady is not suggesting she has an employment claim. What I asked you was, you say that judicial review has some unalterable meaning as a matter of substance. I was asking, what is it?
Okay, very well, very well. We give the meaning. I think it's very early, paragraph 5 of our written case, page 35. Page 35. Paragraph 5.
Sorry, paragraph?
Paragraph 5.
5, thank you.
Page 35. Judicial review under the common law and the law of Antigua by virtue by the Common Law Declaration of Application Act is a proceeding in which the legality of or the procedure by which a decision was reached is challenged. And what we say, if the decision in substance is one of an employment dispute, those type of decisions do not fall under judicial review, or at least ought not to be allowed to proceed, particularly in circumstances where there is an alternative remedy. That is what we say.
But surely that amounts to an argument that this wasn't judicial review. Therefore, because you say it's a private employment dispute, wasn't judicial review, therefore didn't need leave.
Perhaps I need to be clear. She brought it as a judicial review claim. Sorry.
But can I put the whole thing? Therefore, what you were really seeking to do was to have it struck out as not suitable for an administrative action at all.
I was speaking while you were giving the first part of your sentence, so I didn't quite hear you.
Yes. I thought that what you just said was that it amounted to the fact that this was not judicial review. You say she brought it as judicial review, but it wasn't judicial review. But the argument that was advanced in the lower courts was that it required permission because it was judicial review, not it was not suitable for an administrative remedy of any kind and therefore should be struck out. So that's where I need the help.
Yes, well, here's what I would say. The appellants viewed the respondent's action in the High Court as a claim for judicial review. That was the appellant's view of the respondent's claim. We say, the appellants that is, because she had not applied for leave, that the claim brought was a nullity. The answer the respondent gave, this is not a claim for judicial review. This is a claim for a declaration. But as I draw the court's attention to what was stated at paragraph 7 of the High Court judgment, the issue is whether or not this is a claim for judicial review.
Mr. Dorset, am I correct in my understanding then that you're essentially distinguishing two matters? The first is your submission that the form and substance of the proceedings which have been brought amount to an application for judicial review, but at the same time you're saying that the actual subject matter of the proceedings is not amenable to judicial review. Yes.
I think that's a very fair way of
It's the absence of argument below, or at least the absence of decision below, on that second point, which puzzles me. You say that you raised it 42% of the time, you said?
Yes, it was 42% in our written case.
I see. Well, that's very precise.
And in fact, my lord, if I can draw the court's attention, it's right there in the Court of Appeal judgment, which begins at page 128. And if you look at paragraph 18, which the board latched on, Sir Gerald,
Postulated, I see, yes.
Yes, he posited that the subject matter of the complaint against the cabinet is one of private law.
Yes.
So we had argued the point in the written submissions.
Sorry, forgive me, you're reading from...
Page 139.
Thank you very much.
Page 139. And
yes,
if you, as you continue to read, beginning there, look at, for example, paragraph 19, the argument that was put forward, the right to dismiss an employee. That is a right to be determined in the industrial court. Paragraph 20, there is no need for Ms. Isaac's case to be litigated as a public law matter by the filing of an application for an administrative order, whether in judicial review or otherwise. It would be in the interest of all that the parties concentrate on the main issue, one of private law, which is the suspension and the subsequent constructive dismissal, as alleged, violate the rights under the Labour Code.
Well, that's what your side is asserting. Yeah. As a matter of interest, can I just ask, I mean, if your side was right, would the industrial court be the right tribunal? If you look at your case, paragraph 22, page 40, we have the definition of employee, meaning any person who enters into or works under or stands ready to enter into or work under a contract with an employer, personally to perform any services or labour, etc. And the term includes X, Y, Z. And then the last phrase, but the term does not include established employees of the government. What does that mean?
Yes, in Antigua we have a curious system, if I may say so.
Yes. So is she or is she not an established employee?
She's a non-established employee.
A non-established?
Yes.
I see. Established means who? Right.
Established employees are persons appointed by the Public Service Commission.
We have the same,
yes,
effectively the same concept here of established civil servants and non-established.
That's right. So persons who are so-called established employees and who are appointed to their position of employment by the Public Service Commission, when they have grievances, there's a separate tribunal.
Right. All right, so you say she could go to the industrial court.
Yes.
Does she have to? Does the industrial court have exclusive jurisdiction?
Well,
if so, where? I mean, you say it's the court prescribed by law, but that doesn't mean it's has exclusive jurisdiction.
Well, what we say is that under judicial review, and certainly under the Constitution.
No, just I see, you say under the Constitution, right? We've got that.
You got the court prescribed by law, and when you look at the Industrial Court Act, it is clear that that court was established to deal with employment decisions. And my lord, again, going back to
does it have exclusive jurisdiction?
For employment matters under its remit.
Yes, but for example, in this country, if you fail to, we had a case about this not very long ago, if you fail to bring your case within the time limit for bringing a case to the employment tribunal, you can nevertheless bring your claim to the High Court,
Well,
if it's of a type which falls within the jurisdiction of the High Court.
Thankfully, in Antigua, there's no time limit in the Industrial Court.
Yes, okay.
Yes, but the question remains, could you bring a claim in the High Court?
Well,
Why not bring an action for breach of contract and damages?
my experience, my lord, is that all employment matters.
Maybe there are cost advantages in going in the Industrial Court, I don't know, but...
Yes, and to a certain extent...
But we're asking about jurisdiction, you see. You say it's got to go off there, but...
Well, my lord, if I may just draw the court's attention dealing with the issue about jurisdiction of the Industrial Court.
Yes.
If I can draw the court's attention to paragraph 30 of our written case, page 45.
Right.
Page 45. Paragraph 39.
Thank you.
Paragraph 39.
Just I'm working off a different copy.
39.
Page 45.
Yes.
Again, what was held in the Michelak case, that in this country, the UK's employment tribunal was designed to be a specialist forum for the resolution of disputes between employee and employer, and was given a comprehensive range of remedies
Yes.
which could be deployed to meet the variety of difficulties which would be encountered in the employment setting. And in the circumstances of that case, the Michelak case, a case concerning alleged employment discrimination, the employment tribunal offered the natural and obvious means of recourse in respect to the claimant's survival.
Well, I think you have to face up to a slightly different problem here. The UK context is not going to be terribly helpful, but the problem here is, rightly or wrongly, the claim is presented on the basis this is not an employment claim. So the choice is, can it be pursued by declaration, or should it have been pursued by judicial review, or should it have been reviewed, actually, should it have been pursued, simply in the High Court?
Well,
there's no question on the claimant's case of her having to go to the Industrial Court because she says it's not an employment claim. And she's entitled to pursue a claim which is not an employment claim. It may be hopeless, it may fail, and you'll win on the basis that, in fact, she's wrong. These people, or at least one of them, the Cabinet, were her employees. But if she fails on that ground, that's the substance of the claim. And
my response, my lord, is that she may say, for argument's sake, for what I call legal argument, that my claim in the High Court is not an employment claim. Yes. But that argument, we respectfully submit, is undercut by the facts of the case. And when you look at the affidavit...
No, we're not deciding the facts of the case.
No.
The affidavit recites the same history because, not surprisingly, it is the same history for both claims. But the affidavit in this case notably does not claim the damages for breach of contract, which is claimed at the end of the other affidavit in the other case, in the Industrial Court case. So she is respecting a difference between them on her case, and we can't prejudge her case.
No, what I'm saying, my lord, is that when you have, in what in essence is two proceedings, dealing with the same, what we say, issues and facts,
Yes.
it is only proper that those proceedings proceed in a single court and the court most appropriate to deal with the matter.
Well, that would depend on whether there was a single court which was competent
Yes.
and appropriate to deal
And we
with.
say that the industrial court is, and we give,
No, you can't. The industrial court only has jurisdiction, as I understand it, whether it's exclusive or not, over employment issues.
yes, but
And she says this is not an employment issue, this is a claim against a third party. It may be that, I mean, I don't know, you could ask the industrial court to send this perhaps, this employment issue to the High Court if you want them all in one proceeding. But I don't think you can ask the reverse.
yeah, for the High Court to send it to the industrial court?
You can't send a non-employment dispute to the industrial court, can you? If you have a claim for inducing breach of contract
No,
or for tort, you can't say, no. Well, she says that this claim is of that nature. She says it's a claim against people who weren't her employers but who interfered with her.
Yeah. I mean, on any view, the minister was not her employer. Whatever else he was, he wasn't her employer.
Okay, but,
And she's seeking to have the court determine whether he had the legal authority to give her instructions as to how she carried out her work.
no, man,
That couldn't possibly be determined in the industrial
I'm
court.
certainly not suggesting that the minister is employed. The minister was kind of more the delegate of cabinet. He was a delegate of cabinet who was basically the front man.
Well, we don't know that. There's no
Well,
evidence.
yes, she's seeking to have, I mean, the declaration she's seeking will require the court to consider that sort of argument.
Well, again, I appreciate if we don't want to get too much in the facts, but again, just going back to the issues
Yeah.
that are before the court, as stated in the statement of facts and issues.
Yes.
With respect as to issue one,
Sorry, I've temporarily lost the
page
same.
31, page 31,
I've got them, right.
page 31, page 3.1.
Right.
As to the first issue, was the fixed date claim form filed by the respondent an application for judicial review for which leave was required? Our answer to that is yes. It was an application for judicial review for which leave was required. As to the second issue, which has been agreed between the parties, is the nature of the controversy disclosed in the claim form, a private law claim, involving a dispute, for which the appropriate forum was the industrial court, notwithstanding the fact that the respondent was employed by a public authority. And what I would say, irregardless of whether one determines, and I'm not asking this court to decide on it, but it is, I think, agreed that she was employed by a public authority.
Yes.
Yes, so the question for determination is still live. Given the fact that she was employed by a public authority, is the nature of the controversy disclosed in the High Court claim a private law claim involving an employment dispute for which the appropriate forum was the industrial court? And we respectfully submit, when one looks at the matter substantively, it is in fact a private law claim revolving around an employment dispute for which the industrial court is the appropriate forum. That is what we say. I would just, if I may, I just want to respond to a few points in the
Yes,
respondent's case.
absolutely.
Among other authorities, the respondents rely on the Shoesmith case.
Shoesmith, right?
Yes,
Yes.
We accept the fact, and we said it again.
Wait, just wait a minute. Yes, carry on. Yeah.
At page, it's the second page of the ICR report. The second page of the ICR report. We accept that office holders who are dismissed, where there has been no regard for the rules of natural justice, those kind of decisions are amenable to judicial review. We accept that. Right. But just because a decision is amenable to judicial review does not ipso facto mean that it should proceed on judicial review. Now, in the case of Shoesmith, as is disclosed at paragraph 99 of that case, this was an exceptional case. Unusual circumstances. And it appears that, in fact, there was proceedings in the employment court. There were, I think, 3 parties, the employment tribunal, the employment tribunal, and it appears that there would have been a very serious cap on the amount of damages that would have been recovered had that proceeded. And the paragraph shows the unusual circumstances which made it, in the view of the court, to allow this matter to proceed by way of judicial review.
But I think I'm right in saying, and I think maybe in one of the cases, maybe in Mr. Simon's case, that the boundaries between judicial review and private litigation or ordinary litigation in this jurisdiction have become slightly more porous. I remember being in one of the first cases, in fact, on the subject, which went to the Court of Appeal, and this seems to be in the same tradition.
Yes, yeah, but the short point I want to make is that when one looks at the Shoesmith case, we must be mindful of the unusual circumstances. Yeah. And we do, in fact, accept the fact that office holders improperly dismissed without lack of natural justice are amenable. But again, the caveat is that if there's an alternative remedy, that ought to be, that might serve as a bar from proceeding. My Lord?
So, forgive me, you say that there is available an alternative remedy in the circumstances of this case,
yes,
which is in the industrial court.
That is correct, yes, in this case.
But it couldn't grant the declarations.
Yes, it can.
That is all.
Yes, in fact, we have made that argument, and we have referred to the legislation and the cases that we think establish that point. My Lord, we draw the court's attention to we begin at paragraph 34, which is kind of a summary, and then we detail, beginning at paragraph 35, the various provisions of the Industrial Court Act and how our courts have ruled on it, and in particular, the powers invested in the court at Section 8.1 of the Industrial Court Act. And the case of Liat 1974 Limited versus Tomlinson, and what the Industrial Court Act talks about that court, the industrial court, shall have such rights, such powers, rights, and privileges as are vested in the High Court on the occasion of an action. And what was held in the Tomlinson case is what those powers were to ensure that the industrial court had all of the rights, so all the powers, rights, and privileges which could guarantee its ability to be effective in discharging the functions for which it was established. And so what we say is that the power to issue a declaration that what was done in this employment context was unlawful certainly is within the power of the industrial court. Very much is.
But who are the parties to proceedings, not these proceedings, but generally speaking, who are the parties to proceedings in the industrial court? The employer and the employee?
Yes, ma'am.
Right, and at the moment it stands as an action against the Board of Education.
Yes.
Supposing that's correct, what would be the power of the industrial court to make declarations in relation to the conduct of the cabinet or the minister?
Well, that is why we have brought our application in the industrial court, saying that the Board of Education is not employed.
No, it begs the question. I mean, she's entitled to pursue her claim, you know, and unless and until you strike it out as being hopeless or vexatious, she's entitled to have her claim considered by us on the basis on which she's pursuing it, isn't she? And we have to consider, on the face of it, we must take it to be an arguable claim and ask, where does it belong? Or where can it properly be brought?
Yeah, well, what we respectfully say is that when one properly considers it,
Yes.
our argument, which we hope the court will accept, is that it is a judicial review
Yes.
matter.
Yeah, well, I think that's a basic point that you come back to. Right.
So, I don't know if there is a... yes, my Lord, I think that is it for...
Well, you have a right to reply, Dr.
Yes,
Francis,
yes.
So for the moment, is
Yes,
that
my
it?
Lord, I think I have presented my argument. And
Thank you very much indeed. No, very helpful. Now, sorry, what was the name? Where's it gone?
Simon.
Thank you. No. I'll invite your junior, whose name was given to me a moment ago, but is not on the list.
no, he's
He's not your junior.
he is...
Right, there we are. Thank you very much. Then, yes, Mr. Simon.
May it please you, my lord, and my lady. Let me begin first by answering the question as to whether or not the industrial court has exclusive jurisdiction in respect
Yes.
of employment matters. And the short answer to that, it does not. Nowhere in the Act is it given exclusive jurisdiction in respect of employment matters. What the Industrial Court Act does, however, it expands the remedies in respect of unfair dismissal.
Yes, I wondered about that. It's like our tribunal system. Yes.
It is. So that you may go to the High Court with a claim for unfair dismissal or wrongful dismissal,
Yes.
which is a common law concept. But in terms of the damages or the remedies, whether it be compensation, you are not going to get what you would obtain in the industrial court, because the industrial court specifically provides for the various remedies. And it allows for severance pay, it allows for immediate loss, future loss, and in terms of loss of allowances. So that's the first point which I wish to make.
Right.
Second point is that your lordships and my lady will note that the fixed date claim which was filed by the respondent was filed after she considered herself to be constructively dismissed.
Right.
He says she's unemployed in the affidavit.
So she's unemployed.
Yeah.
In fact, by letter dated August 22, 2014, which is at page 160, the Respondents' Council had written to the Board of Education informing them that the respondent considered herself constructively dismissed. And it's as a result of that constructive dismissal that a claim was filed in the Industrial Court on October 16, 2014. And that is at page 162 of the record. So on the filing of the fixed date claim seeking a declaration, the respondent was not employed, and therefore the respondent was not seeking any coercive remedy in her claim. Simply put, the respondent is seeking clarity on the law in respect of the authority of the Minister of Education, the second appellant, who was instrumental in having Cabinet suspended. If I take the court to page 85 and 86 of the record, at page 85 we have the letter coming from the Secretary to the Cabinet. And included or attached to that letter,
Yes, was the internal letter from the
Minister of Education.
Minister of Education, yes, exactly.
And you will note that the Cabinet Secretary says at the bottom, page 86, please note that the reasons contained in the letter by the Minister are the reasons for which you are suspended. Now, what does the Minister say? What does he complain to Cabinet in respect of? And we see it at 1, 2, and 3, where he says the Executive Secretary acknowledged and declined to follow my directive. Secondly, again, he sought from her details of the staff of the Board of Education, and the Executive Secretary acknowledged and declined my request for the said employee details as requested. And point 3, these actions were clearly in defiance of clear instructions given by me and were a direct attack upon my authority in the circumstances. Question which arises, and the issue therefore, is did the Minister of Education have such authority?
Yes. All right. You said a moment ago that your client is simply seeking clarity on the law.
Clarity on the law.
What's her interest in doing that?
One, it will certainly assist in respect of her employment issue, which she has in industrial court, as to whether the suspension by the Cabinet was properly done. And secondly, it allows her to get, possibly from the High Court, and we have claimed, exemplary damages for the unauthorized and unlawful action of the Minister of Education.
And presumably also from the Cabinet.
From the Cabinet.
Yes.
Yes. And we have also in the claim for declaration also indicated that there was an investigation,
Yes.
which was initiated by the Minister of Education. The respondent was never called to answer any questions in respect of the investigation. And yet, the preliminary report of the investigation was made public on the radio station. And it was very derogatory of the respondent. In addition to which,
That's a private radio station, is it? Or-
it's a private radio station,
Yeah, I see. Right.
but it, how should I put it? Things are very strange in our country. It supports the government in office, unconditionally, because it actually was commissioned by former members of that very same government.
Yeah. But fine, anyway.
So there is that aspect of it.
So the claimant was not called at all.
Sorry, my lord?
No, so not called at all to give answers.
No, she was not called at all.
Yeah, give answers to the investigation, yeah.
Indeed.
And you're not simply challenging the investigatory process as having been in breach of natural justice, but as I understand it, you're seeking damages for the effect on her reputation of the publication of a report, which you don't use the word misfeasance, but it's a sort of misfeasance in public office claim, as I understand it.
Respectfully, indeed so. And in fact, if we look at page 96 of the record, from 96 to page 99, we have exhibited there comments which were made following the
Yes.
publication of the report
Yes.
by persons on social media. And social media can be exceedingly destructive, especially in a small society like Antigua and Barbuda.
Yes.
And when we look at the comments, we can see how very damning and derogatory that these comments have been, to the point where it has affected the respondent from obtaining employment, alternative employment.
So that's, in a nutshell, how you put it.
In terms of the claims that we have made
Yes.
for declaration. Now,
And how do you fit it into the legal scheme? You say you're entitled to produce, claim a declaration there. It's not judicial review. We need help on this.
very well. We first of all say that there is both a public law element and a private law element in the employment of the respondent. We accept that her appointment was by cabinet and that cabinet was so authorized by virtue of section 11(1) of the Board of Education Act. That appears at page 472 of the record. I have no issues with respect to that.
And you presumably accept, therefore, that the Cabinet had the power to suspend her?
We go further and we say, yes, when one looks at the Interpretation Act, he who appoints has the power to disappoint. So that Cabinet does have the power to suspend as well as to terminate. We have no problems in respect of that. We, however, say that her employment was by the Board of Education. We look at page 472 of the record, where we have the Board of Education Act. We begin at 470. Section 4(1). The board shall consist of such members. No, I'm sorry. I think I'm quite. 472. Correct. Section 11. Section 11(1). There shall be an executive secretary of the board who shall be appointed by the cabinet. That's clear. Subsection 2. The executive secretary shall be the chief administrative officer of the board and shall, subject to the provisions of this act and the general directions of the board, be responsible for the direction of the staff and for the management of the board. So specifically, the piece of legislation provides that the authority in respect of the executive secretary's actions are the board's.
Does that make the board the employer?
It assists in respect of the determination as to whether or not, and I will come to that. We look at section 12(1).
Well, I mean, does she have to have an employer?
Eh?
Does she have to have an employer? Could she not have a freestanding office?
She could have, but she did not.
No, I say anyway. You say it was she has an employer, and that's your industrial court claim.
Yes, we're saying that she did. She did have an employer.
Right.
12(1) again indicates that the executive secretary may from time to time, acting upon advice of the board, appoint persons to the offices, to be officers or employees of the board.
Yes.
So there again we have where she has to act within the remit of the Board of Education.
Right.
And then what is very interesting, because what we submit is that there is mutuality of obligation existing between the respondent and the Board of Education. And I wish to draw the court's attention to pages 66 to 67 of the record. And that comes right after the submissions of the respondent. And it is a transcript of the evidence which had been given under cross-examination by the then chairman of the board at the industrial
I think this is referred to in your case, and it may be that we've all read it, in fact.
Yes.
But, I mean, basically, your point is that she said that her dealings were all with the board.
All with the board. And that's not the respondent speaking, that is the chair of the board.
Yeah.
The then chair of the board.
Or he said, yes, he said. Yeah. Her dealings.
She has been employed by the board herself prior to her appointment as the chair. And you will see in respect of every issue, it was the Board of Education.
Yes.
The board paid her, the board deducted statutory contributions.
Ms. Simon, we're not deciding here. We can't decide who she was employed by. We appreciate your cases, and we see that you have material on which you rely. But
I respectfully
we appreciate that the present proceedings are not framed as being against anyone who is her, on her case, her employer.
Indeed.
Yes.
So the issue, we say, is is in respect of the public law element, given the exercise of Cabinet's limited authority over the respondent. We look at the letter from the appellant minister, the fact of the suspension of the respondent, and we see that, properly speaking, and correctly, we are seeking declarations in the High Court in respect of the actions of the minister. Does not affect her employment status, because she no longer is employed and she's going to the industrial court for remedies in respect of a constructive dismissal. But what we do need is the court's clarification of the authority of the Minister of Education.
Right.
And if we look at the Board of Education Act, which is begins at page 469 of the record, the functions of the minister are very clear. We look at section 4.3. The minister is to appoint members of the board. Section 4, subsection 4, if the chairman or the deputy or any other member is unable to act, the minister may appoint someone in their stead. Subsection 5.1, if any member of the board or the chairman resigns, the writing must be addressed to the minister. Subsection 3 of section 5, the minister may, at any time and with the approval of the cabinet, revoke the appointment of any member.
Yes.
Section 9, subsection 1, the minister shall at the beginning of each financial year forward to the board government's policies relating to matters provided under this act. Section 10.2.
What about D? Directives on any other matter that the minister may see fit.
Yes.
That must be general
And directives generally to the board.
at the beginning of each financial year, not on a day-to-day basis.
And to the board.
Yes. Right.
Then we go to section 10, subsection 2, where the minister is under a duty to submit to the House of Representatives the auditor's reports and accounts of the previous year. Section 12, subsection 2. The terms and conditions of employment of officers and employees of the board shall be prescribed from time to time by the minister. Then section 23, subsection 2. Where the board creates a Board of Education fund, and any disbursement from that account shall be made only upon the written instructions of the minister. Section 24, subsection 2. The accounts of the board shall be prepared in such form and at such times as the minister may direct. Subsection 4. The board shall submit to the minister every account certified by the appointed auditor. Subsection 5. Again, the minister is to lay a copy of those accounts before the Parliament. That constitutes the complete functions of the minister. And respectfully, I say to the court that the minister's responsibilities and duties are always in respect of the Board of Education. In none of these sections has the minister been given any authority in respect of the executive secretary. And there we have cabinet suspending the respondent because the minister complains that she has failed to follow his directives. We recognize that the Board of Education is a public authority. And it is therefore necessary for the court to make a pronouncement as to whether or not such action by a Minister of Education, whether this one or for future reference, is correct given the context of the Board of Education Act. That is why we seek declarations in respect of the Minister's actions. Now, we have gone under CPR 2000, Part 56. As your Lordship has correctly pointed out, a declaration is simply one of the applications for administrative orders that is allowed under Part 56. And we see 56.1, which makes it very clear that applications, A, can be by way of originating motion for relief under the Constitution. B, for a declaration in which a party is the state, a court, a tribunal, or any other public body. We say the Board of Education, whether it be the Board of Education, which we claim are the employers, or whether it's the Cabinet, which the appellant claims is the employer. They're public bodies, and therefore susceptible to declarations. And then C, judicial review. So it is very clear from the CPR 2000 that judicial review is a separate and distinct administrative application from that of a declaration. Subrule 3, 56.1, Subrule 3. The term judicial review includes the remedies, whether by way of writ or order, of certiorari for quashing unlawful acts, mandamus for requiring performance of a public duty, prohibition for prohibiting unlawful acts. None of these three coercive remedies have been included in the claim brought by the respondent. And the reason for that is very simple, because the respondent is no longer an employee, no longer employed. Therefore, she's not seeking any coercive remedy. She simply is seeking clarification as to the extent of the authority of the minister under the Board of Education Act.
Under the first declaration, she is seeking a declaration that a decision is void.
Indeed.
Now, what's the difference in terms of coercion between a quashing order and a declaration that a decision is void?
Because a declaration is not enforceable. I think this is standard law, that one can have a declaration, obtain a declaration from the court, and we basically expect that parties will guide themselves accordingly. But a party may very well refuse to. That is why it's important, if you're seeking a matter of that nature and you are personally affected, that some coercive remedy should also be part and parcel of what you seek.
If the minister subsequently tried to assume that the declaration was obtained and the minister subsequently sought to rely on that decision, he would be met, wouldn't he, with reliance on the declaration?
Indeed. The respondent can then rely on the declaration if the minister subsequently acted along those lines, or if the minister acted in respect of any other executive secretary. And in fact, when we go to the industrial court dealing with the issue of the constructive dismissal, the declaration by the court would certainly be assisting, because the industrial court would have to take cognizance of the declaration.
But could it be litigated in the industrial court, whether the minister had the powers that he purported to exercise?
We are saying the respondent's position is that Cabinet is not an employer, is not the employer. We can only go to the industrial court in respect of an employer. So it really only deals with employee-employer relationships.
But as I understand your case in the industrial court, it's that the board, by tamely acting on an assumption that the suspension was valid, locked out your client, and that's what constituted her constructive unfair dismissal.
Indeed.
Because they should not have accepted the Cabinet's suspension and had no basis for locking her out.
Well, we did not even go that far, but basically that is indeed so. What actually happened was that the Cabinet suspended her for 28 days.
Yes.
The industrial court definition of suspension is 28 days. She goes back to work and meets her office, her locks changed. And then she's told, we meant 28 working days. She's not even given a letter in respect of that.
I've understood that.
Yes, the press release.
There's a press release which says that too is based on the directive of the Minister of Education.
And it's also based upon the directive of the Minister of Education.
Yes.
That is indeed so.
But if the Board of Education was entitled or bound to act in the direction, in the light of what had happened with the Minister, because he was entitled to give directions to the Executive Secretary, that might put a different complexion on things.
Indeed.
Therefore, the question is, can the Industrial Court determine what the Minister was entitled to do?
To a certain extent, the Industrial Court may make pronouncements on it. My problem and issue is that the fact that the Cabinet has the power and the right to appoint and also to disappoint, that action by the Cabinet would have to be advised by the board. In other words, the Cabinet could not just one morning simply say, I'm going to suspend the Executive Secretary. There should be a report coming from the board in respect of Cabinet's action to either suspend or to terminate the services of the Executive Secretary.
But if your client had simply sued in the industrial court, saying, I've been constructively dismissed, and the case was pleaded out, and an issue which might be decisive or influential upon the question whether she had been constructively dismissed was whether or not the suspension had been lawful, a lawful instruction of the Cabinet, then surely the industrial tribunal, if those were the only proceedings, the industrial court, could determine that question on its way to deciding whether she'd been constructively dismissed.
Indeed, it could. But our remit to the industrial court is limited in respect of the suspension only to the fact that the suspension was extended unlawfully.
Okay. I'm just wondering about that. In this country, the supervisory jurisdiction of the court over the legality of the acts of public authorities is possessed only by the High Court. And other courts can deal with issues which arise collaterally. For example, if you're prosecuted for the breach of a bylaw, then it's permissible for the court in which you're prosecuted to determine, if you run a defence that the bylaw wasn't validly made, then the court, it could be a magistrate's court, would have to decide that issue. But that's an exception to the general principle that it's only the High Court which possesses the common law supervisory jurisdiction. And I would imagine that the industrial court's jurisdiction will be purely statutory.
It is indeed purely statutory.
And So
it doesn't have that wide ambit
no.
that the High Court would have.
Yes. So
Jurisdiction is limited and only in respect of the employment issues.
Yes,
So it will
yes.
have to look at the relationship between the employer and the employee.
yes.
Because it wouldn't be concerned with why the Board of Education, would it, or with whether the Board of Education was entitled to act on the directive of the Minister of Education. It would surely be concerned with whether the Board of Education was entitled to act vis-à-vis your client on the basis on which it did. Would that, yeah.
But the reason I started on the questions is because you said that the answers that you would get from the High Court would assist in the industrial court action.
It would, because we would then draw it to the industrial court's attention, and the industrial court would have to take due notice of the declarations which have been made by the High Court.
Well, that was an interesting question because it's not between the same parties. But leave that aside. I mean, your primary case, as I understood it a moment ago, was that you were interested in the High Court litigation for itself. It could yield some considerable benefits in terms of exemplary and other damages.
Indeed. And it also would give, how should I put it, in respect of the public, of future behavior of the cabinet or a minister of education.
Yeah.
It would certainly be enlightening in respect of how far they can go, what their authority is, and how they can act. And we think that is important in respect of the public nature of cabinet.
If she's very public-spirited and wants to establish these points, are you saying purely as a matter of public-spiritedness as well?
We are very public-spirited. The court will note that we actually commenced the action against in the High Court before we made the reference to the industrial court.
Yes.
So the situation was very clear in the mind of the respondent. Does the minister have the power to give me directives? And can he therefore go to cabinet and say that I've given directives, they have not been followed? On that basis, you cabinet should suspend the employee. We have to make sure that this does not happen again in our society. And the only way that we can deal with that situation is by going before the High Court. Now, the issue of judicial review, as my Lord President has pointed out, is totally different here in the UK. It's governed, first of all, by your Supreme Court Act of 1981. And then, in respect of your UK judicial review, Part 54 provides certain situations where you should go by way of judicial review if you want a declaration. And alternatively, you may in certain circumstances. We have not gone that far. So you do not necessarily have to go for judicial review if you're simply seeking a declaration. However, we have two cases on point which I have referred the court to, where declarations have been sought, but the court recognizes that the litigant not only wanted a declaration, but wanted a mandatory order and a certiorari order. And the court says quite clearly, since you're seeking prerogative remedies in addition to the declaration, you must go by judicial review. The two cases that we have referred to in this matter there's the SVP Green Party versus Supervisor of Elections. We refer to it in paragraph 7, page 51 of the respondent submissions.
Sorry, I missed this reference, I'm sorry.
Page 51 of the record.
Yes, thank you.
And it's referred to in paragraph 7. the submissions. Trying to determine the, because it is also, we've also given actually the case. What page is it? Yeah, but the other one, which is, yes, O'Neill. 528. And then there is a Blake one also, which is at page 458 of the record.
Sorry, do we have a Green and O'Neill and the Green Party? We don't have that.
That was in St. Vincent.
Yes.
We actually have one in Antigua also.
It's page 528 in the authority.
Yes.
528.
528.
Thank you.
And in both of these cases, because of the nature of the remedies sought, and not merely the substance of the claim, the courts determined that judicial review would have been, should be the proper procedure and process.
And it presumably somewhere along the line that jurisprudence says if it can be seen that you're dividing up what is in really one claim for a declaration followed by coercive order into two claims, namely first going for a declaration, but it's obvious you're going to go for a coercive order if you get it.
Indeed.
You can't escape the requirement for leave by splitting it into two.
Indeed. That exactly was the point which was made by the court. Can't split it into two. Has to be one action with its various remedies. Once you've included a coercive remedy, then you must seek judicial review.
Yes. Yes, when one sees in Blake at page 60 the order sought, it's clear that it wasn't actually a declaration of rights, but they were seeking a declaration that that someone ought to be removed from office by the Governor-General, and such removal followed up by
of the Prime Minister.
Then the Governor-General ought to issue new writs. So effectively it was just a way of dressing up what were mandatory orders in...
Indeed. It was a cloak, as far as the court was concerned.
Yeah.
Because in effect, you were seeking more than just a declaration because you wanted the Prime Minister removed from office.
Yeah.
And for that, a declaration alone is not sufficient. Because it's the very same point which I've made in terms of a declaration. It simply declares the law, and the party against whom the declaration is made may or may not conform to the declaration. So that it is important that you seek a coercive remedy in addition to the declaration in those circumstances. The respondent is no longer employed. Doesn't care to be re-employed by the board. So she's seeking remedies for unfair dismissal in the industrial court. But in addition to that, she's also seeking clarity from the High Court by way of declaration in respect of the actions of the respondent, the appellant Minister of Education.
The declarations which are sought are not simply prospective, they are specifically related to the events which have occurred.
Indeed. They are. But they would also, what I should say, not only throw light in respect of the proper interpretation of the statute vis-a-vis the Minister of Education's authority, but it would also give general guidance. And I think it is in the interest of the public, that's how we saw it, in the interest of the public, that there be clarification in this matter.
Can you just help me? Sorry, the other authority in paragraph 7 on page 51 hasn't got a reference. It doesn't seem to be in our authorities bundle.
Which one?
Is that right, Ivan?
Is that the O'Neill? Is that at page 528?
Ah, 528.
It's at 528. It's a High Court judgment.
It's quite interesting because it's a case where declarations were sought, but various regulations and directions were null and void, but that wasn't regarded as by the court as a problem. The problem was that, as well as all these declaratory orders, the claimant also sought, page
Mandamus.
531, an order of mandamus.
That's indeed so.
And yeah,
And you'll see at paragraph 3 on page 531 of the judgment, the order of mandamus be issued against the supervisor of elections to allot symbols to the yes vote and the no vote.
Right. Well, bearing in mind the time, shall we look forward to your continuing your submissions at 2 o'clock, Mr. Simon?
I'm so guided,
And I-
respectfully.
Awesome.